Dr. Michael Dusche studied philosophy, German literature, and linguistics in the University of Tübingen, Germany, where he obtained his master's degree in both the subjects in 1993. He worked his way towards his doctorate of philosophy as a fellow of the German Research Foundation, DGF, at the Center for Ethics in Sciences and Humanities, Tübingen, under the guidance of Autry Frick. Oh, am I right? Oh, perfect. And who's working in philosophy and Volksritberger in international relations. And later under Professor Alex Honnold in Frankfurt, where he successfully defended his dissertation on John Rawls and global justice in December 1999. In 2000, he joined the Center for German Studies at the Jawaharlal Nehru University, New Delhi, where he worked for 5 years as assistant professor and DRR Day lecturer. Since 2005, he's been back to India on various research assignments, and in 2006 for DRR Day, for 2007 for BMBF, in 2009 and 10 as a fellow again at JNU Institute of Advanced Studies, and in 2013 as senior fellow at the Center for Study of Developing Societies, CSDS Delhi. In 2014, he joined us at the Manipal Centre for Philosophy and Humanities as a senior fellow. He's actually an assistant professorship rank and for sociology. Dr. Dusche has published 2 monographs, one in German on Rawls and global justice, and one in English, which is called Identity Politics in India and Europe. He has co-edited a special issue of the Indian Journal of Medical Ethics along with Silke Sniktans, right? Sniktans. And he edited a volume on justice, political, social, and juridical with Rajiv Bhargava. Michael is very particular about pronunciations, in German particularly. He is currently working on non-state legal practices in India and on the ethnopoiesis of Indian life worlds. And I'm glad to say when the idea for this conference came around, was one of the first people that Michael discussed along with my other colleagues about this. And I am equally excited to see this happen. And it's only the beginning of large things we have planned, and soon hopefully we'll get on to those things too.
It is
Michael.
largely thanks to Mira that I have come across a rather esoteric aspect of non-state legal practice, which I'm going to present now, hoping that it will not be too esoteric and too strange in this context. But I'm also referring to the debate of legitimacy, Habermas and Rawls, and the paradox of modernity. So I think our 2 papers are kind of speaking to each other in hopefully an inspiring way. Let's see. Now, we have heard in the previous very interesting papers about various problematic aspects of non-state legal practices, where examples of how communities or corporate groups settle their disputes without necessarily resorting to oppressive violence. But this, of course, is also, we have also noticed the interference of power relations in the whole story of law, and we have, I've raised this methodological issue that we can speak of non-state law also in a very euphemistic way, in an illegitimately euphemistic way, calling things law which actually are just sheer oppression or dominance. But leaving all these things aside, I would like to look at a rather harmless example of non-state legal practice, which interestingly delegates all disciplinary power to spirits. And this doesn't seem to be, although these spirits are all very local phenomena, the phenomenon as such seems to be a pan-Indian one. All over India, there are examples of how legal practice which completely refrain from using force. The enforcement of law is completely delegated to spirits such as devas or bhutas, devtas or jinns. In the first part of this paper, I will argue that these spirits are efficacious legal institutions. To argue thus, I claim that we can leave aside the question whether these spirits are real in the scientifically objective sense. It suffices to show that their existence is an intersubjectively shared belief. Such a belief, as part of the social imaginary, as Castoriadis has defined it, is efficacious just like any other social institution whose reality is grounded in the intersubjective social world rather than in the objective world of science and the subjective world of experience. And here I'm using Habermas' threefold division of these 3 world concepts. I'm comparing 2 legal systems, one spirit-based and one positive, on the level of ideal types. So I'm not going into the actual practice, and therefore I'm avoiding the asymmetrical comparison of an ideal system on one hand with an operational system on the other. This is what Bakshi had observed in a very early paper in 1979. I think it was first published in a German journal, and then in his book in 82 as the last chapter, where he observes that one of the problems with the study of non-state legal systems is that we always tend to compare the ideal typical version of the state law with the real practice of the non-state law. Of course, that's an unfair proposition. When comparing both systems on the level of ideas, it will turn out that one suffers from paradoxes which the other does not have to grapple with. It will turn out that a system based on positive law, and positive law means enacted law. I'm not talking about legal positivism here, right? It's just enacted law, faces two paradoxes that can only be resolved by resorting to the stipulation of a moral consensus, which is precisely what is said to be lacking under modern conditions, as we have just heard from Habermas. While the system based on positive law purports to be able to do without appeals to an integrated morality of citizens, the primordial spirit-based system is said to be less suited to modern conditions of plurality because it rests on the unrealistic assumption that everybody shared the belief, for example, in those spirits. It belongs to the stable claims of modernist theory that about modernist theories of law that modern society could not be integrated or stabilized based on such beliefs alone, spiritual, moral, ethical, which not everybody can share. This is the whole debate of public reason in Rawls and Habermas. This may be true of Western societies. The claim seems less obvious, however, in the case of post-colonial societies, where in spite of their modernity, people continue to believe in spirits, for example. To the modernist pre-modern societies, with the supposedly more uniform religious beliefs of their members, serve as examples of the allegedly lost unity of primordial times in which a self-standing conception of justice, as Rawls conceptualizes it, was not yet necessary, which could be independent of any controversial religious or secular belief and only based on overlapping consensus between conflicting religious and secular worldviews. This paper will show that a spirit-based legal system, as ideal typically conceived, is not necessarily tied to such romantic and orientalizing ideas of primordial society. On the contrary, it will show that the belief in the efficaciousness of spirits is shared by members of all denominations, in spite of their internal differences in a society like India, which has been highly diverse even or much before the inception of modernity. Anthropologists are interesting methodological questions with the study of spirit. Birgit Meyer, for example, an anthropologist from Amsterdam University, who studies spirits in West Africa, in Ghana, remarks, in the African context with respect to the spirits populating the world of the Ewe in Ghana, I quote, "Spirits elude confinement to the category of religion and appear in all kinds of settings, including politics, economics, and entertainment. Spirits, in other words, are not just there as signs of a traditional past, but reproduced under modern conditions." End of quote. This paper and other contributions of this conference, namely Mira's, will show that in the Indian context, spirits appear and are reproduced under modern conditions, especially in legal settings. One methodological trap that has been exposed in much of the post-colonial literature is that of a stage theory of legal development. And a prominent representative of this approach, in spite of all his trying to avoid that, he's declared himself an opponent to historical determinism or sociological determinism, but Habermas stays kind of wedded to the idea of a society undergoing a learning process, which of course is not a deterministic notion, but nevertheless a notion wedded to the idea of learning stages, where society graduates from tribal or lineage stage to kingdom, empire, early modern state, until they finally reach the level of the fully modern constitutional and democratic state. In terms of legal practices, this entails a learning process, beginning with pre-modern magical or sacral understandings of social order and culminating in the realization of positive, fully democratic constitutional law. As in other domains, so also in the domain of law, this view denies coevalness, contemporaneity to our contemporaries, who take spirits to exist in and behind the world of physical appearance. It is similar to Pater Chatterjee's account of modernity, and I quote, "When it encounters an impediment, for example, people believing in spirits, it thinks it has encountered another time. something that belongs to the pre-modern. Such resistance to modernity are therefore understood as coming out of humanity's past, something people should have left behind, but somehow haven't. This conception of modernity is a normative one, based on a mythical conception of a time-space of epic proportions, a fact which is in plain contradiction with the Enlightenment's claim to help us emerge from our self-induced immaturity. The mythical time-space of pre-modern selves, of the pre-modern, serves only as a narrative device to throw into relief the achievements of the moderns. And I'm again quoting Chatterjee. The curious fact is that the negatively designated historical past could even be found to coexist with the normatively constituted order of modern political life in a synchronous, if anomalous, time of the present. We want to avoid such modernist conceptions of non-synchronism, as Ernst Bloch has once called it, and neglect its obligation to its dialectic. And just as we avoid relegating spirits and their believers to another age, we must also refrain from referring them to an ontological realm different from ours. Spirits for us and for their believers do not inhabit a world other than ours, aloka. They're not relegated to a world of transcendence, but they share with us the very same world we live in, Manushya Loka. Some of the spirits even have a jurisdiction bound to a particular territory. As in the case of the Ewe in Ghana, I quote Birgit Meyer again, the physical and the spiritual are completely entangled. In a sense, spirits and the spiritual are in the midst of the physical. In many respects, the spiritual and the spirits are the powers that shape the course of things and make people act and think in the way they do. End of quote. The physical world and the spiritual world are on the same level. They are not perceived as belonging to two different spheres of reality, one immanent, one transcendent. Spirits administering justice are found across India and amongst diverse communities, such as pre-Hindu in the coastal Karnataka region, Jain, Buddhist, Hindu, Christian, and Muslim. The pre-Hindu belief system of coastal Karnataka includes the spirits of totem animals, wild boar, as you've seen Panchurli here, the leopard, tragic human figures, epic heroes, one of them Muslim, there's Adi Bhuta, royal figures, Rajya Bhutas, semi-gods, devas, and gods, like Manjunath, who's a local version of Shiva. Now, how does a spirit-based legal system work? A farmer who was accused of, these are like evidence from my own students from their villages. A farmer who was once accused of felling trees from the village commons fell from his tractor and broke his hip. He had to plant new trees to appease the devas, after which he recovered. Another example which I have experienced in Delhi with my own maid. A maid has stolen a golden necklace. And then we told her the necklace is enchanted and it will give an illness to your child. You know, we're not saying you, but whoever owns it illegitimately will suffer illness, or the child. So next day the necklace was back. Now I will give an ideal typical account of a society where humans have delegated all their disciplinary powers to spirits. Now what happens? How does the court system work? These are petitions to the jinns in Feroz Shah Kotla in Delhi. Yeah, they put up petitions on government stamp papers to bring their cases to the attention of the jinns. In the event of an offense, the plaintiff goes to the accused and demands redress. Now, I'm generalizing over these examples. Golu Devta in the Himalayas, the jinns of Feroz Shah Kotla, the bhutas here. If the accused does not respond, the plaintiff publicly warns her that she will take the matter to the spirit or the deva. In the case of Golu Devta, she utters a phrase like, Maad lagana, I will put a complaint on you. In the case of Hegade of Dharmasthala, this was the previous example. Yeah, this is Virendra Hegade as a kind of a Jain custodian of a Shiva temple who functions in the area of Dakshina Kanara as a court of appeal for all these bhutas. All the bhutas accept him as the Supreme Court. So cases of all communities, including Muslims, Hindus, and so on, go to this Jain judge, and he helps adjudicate them with the help of 4 spirits who legitimate his rule and to whom he is accountable once in a year in a dharmanima, as it is called, when these spirits are being impersonated by dancers. So in the case of the Dharmadhikari of Dharmasthala, she will call upon Lord Manjunath and utter the words, Matubida Manjunatha. Manjunath will judge the case. If the accused still does not respond, the plaintiff will file a petition with the spirit. At Golu Devta's temple and in the caverns of Feroz Shah Kotla, believers put up written petitions, sometimes on government stamp paper, on the occasion of a bhuta kola in a night-long seance where a spirit is impersonated by a medium. The petition is offered orally. In Dharmasthala, the petitioner submits a complete file to the Dharmadhikari. Now, the accused knows that if he is rightfully accused, he will have to face the wrath of the spirit. If some misfortune happens to him or to one of his near and dear ones, he will attribute it as an action to the spirit. Eventually, the rightfully accused will repay his debt to the plaintiff. In the case of Golu Devta, this takes no more than 21 days. In the case of Virendra Hegade, the Dharmadhikari of Dharmasthala, this may take even several generations, but the case will be resolved. Occasionally, the perpetrator will have to publicly acknowledge his wrongdoing by sponsoring a ritual in which he apologizes publicly before the spirit, before the plaintiff, or before the whole community. In Golu Devta's case, this ritual is called Jagar. In the case of in case the complaint was false, of course, the wrath of the spirit will be upon the plaintiff for contempt of court. In the case of Dharmasthala and the bhuta kolas, there is even a hierarchy of courts in which the bhutas of coastal Karnataka recognize Manjunath and his caretaker in this temple of Dharmasthala as a court of appeal. In each case, the accused is brought to reason because she shares the belief in these spirits, which are known to be capable of inflicting great harm to himself and to his family. Now, looking at the arms of the bhuta, you remember the two swords of Panchurali? Yeah, two swords. We are reminded of the Christian doctrine of the two swords of justice. Here, in this case, it's God giving one sword to the emperor and the other sword to the pope, right? So while justice is deferred to another age, time after time, the day of judgment, in the meantime, justice is being meted out by the secular powers. This presupposes a distinction between an immanent and a transcendent, which is not here in our example. So, unlike in the Christian belief system, where the divine sword will be applied only in a time transcending our times, and the temporal sword used in the meantime by the secular authorities, in the case of the bhutas, matters are slightly different. Since the spirits share the same space and time with us, divine justice does not have to wait for the time after times. It can be executed on this very day and age. Hence, there is no need for a worldly power to wield a temporal sword in lieu of the divine authority. They can completely leave matters to the spirit. But is this a legal system? According to H.L.A. Hart, a legal system arises the moment a system based on primary rules of obligation is supplemented by secondary rules. The secondary rules specify the ways in which the primary rules may be conclusively ascertained, introduced or eliminated, varied, and the fact of their violation conclusively determined. In other words, they circumscribe and institutionalize what Max Weber had called the stuff of people, as Morton mentioned earlier, entrusted with the administration of justice. Hart's secondary rules are the following. 1. Rules of recognition of what should positively count as law. This can be a law code. Rules of change of law, abrogation of old, enactment of new laws, rules for the administration of justice and of adjudication, and rules creating and empowering institutions, that is this stuff of Weber's talks, to carry out these tasks. In the case of our ideal typical society with a spirit-based legal system, one is problematic. There's no code of law, no authority positively determining what should count as law and what not. Laws are known to the members of the society as part of their being in the world. They inform their life world. They are as such form the largely unconscious background of all their actions. The rules are transmitted in a process of socialization in which they are internalized as part of the process of forming a personality system. The personality system then becomes a mirror of the cultural system. And all this is largely unconscious. Like we learn language, we know when somebody speaks the correct sentence or he doesn't, but we could not, maybe if we're not grammarians, point to the rule that governs our language. So in that sense, social rules can also be implicit in social action without being positively determined. 2 is also missing. Nevertheless, this society is not static, but subject to the kind of change that Hart described as slow process of growth. Our society can be said to have a legal order only in virtue of 3 and 4. That is, it authorizes a specific social institution, in this case a spirit, or its representative, the dharmadhikari, or its medium, in the case of the bhutakolas or jagars, to determine whether a law has been broken and which law, and to administer justice. The force exercised on the victim could be interpreted as psychological pressure, with Max Weber, who categorically denies that law exists only where legal coercion is guaranteed by political authority. So Max Weber was quite tuned into this idea of non-state law also. A legal order, according to Weber, exists wherever coercive means of a physical or psychological kind, and he was thinking of church law, obviously, are available wherever we find a consociation specifically dedicated to the purpose of legal coercion. The possession of such an apparatus for the exercise of physical coercion has not always been the monopoly of the political community. As far as psychological coercion is concerned, there's no such monopoly even today, as Weber notes, as demonstrated by the importance of law guaranteed only by the church. End of quote. But for the believer, the psychological pressure is grounded in a real threat of physical sanctions, or that is a disease or a misfortune befalling the perpetrator or his family. Depending on whether you believe in spirits or not, you would describe as real the threat itself or only the fear that it induces in the psyche of the believer. In any case, you would have to acknowledge that the shared belief among the members of the stipulated society gives rise to the spirit as an efficacious social institution of justice. We therefore affirm that although it lacks physical force for the non-believer, a system based on spirits as justices can probably be called a legal system. But what is its significance for this larger debate about India and modernity? While in India and Africa, belief in spirits may be widespread, it is said that the world at large could not rely on something like a shared sacral, moral, or ethical order. The breakdown of the sacral moral order in the time of Reformation in Europe, which led to decades of religious war, was precisely the reason why Christian natural law had to give way to rational natural law and eventually positive man-made law, constitutional democratic law. This process could not be reversed in the West. In India and many a post-colonial country, however, belief in a sacral order has not broken down, obviously. In such post-colonial contexts, it may be worth appraising the merits and demerits of both legal traditions, positive and non-positive. There's no reason to presume that one is necessarily more rational than the other. Then what could be more rational than refraining from the use of physical force in the administration of justice? In the second part of my paper, I will try to create a level playing field between spiritual and positive law so as to avoid the usual skew which has us compare normative models of the state legal system with operational or operative models of the non-state legal system. Comparing both systems at the operative level, one would have to say that there are merits and demerits to both state and non-state law. Thus, I will not compare spiritual and positive legal practices at the operational level as we have done it in the previous sessions, but I'm going to compare the ideal typical conception of spiritual law as laid out in the previous pages with the idealized account of the modern constitutional and democratic state as set forth by theorists like John Rawls and Jürgen Habermas. For both thinkers, the primary reason for having a state-administered and democratically legitimatized legal system is the fact of the breakdown of the sacred moral background consensus, which allegedly supported the social order prior to the Age of Reformation. As I will try to show in the following, both Rawls and Habermas admittedly have to presuppose a shared moral background consensus regarding citizenship, for example, which in itself cannot be grounded in law. So my analysis, I think, is similar in some ways to Professor Varma's. I show this by pointing to two paradoxes of the liberal democratic state. The first paradox is positive law, therefore, the source of our first, positive law, therefore, is the source of our first paradox, the paradox of the free market society. On the one hand, individuals are conceived as freed from moral obligations vis-à-vis each other. This is what creates the market. They are free to pursue their rational advantage. On the other hand, they are conceived as committing themselves to contractual obligations, a point we have discussed with Akhil Bilgrami last December. The ethics of pacta sunt servanda, of agreements must be kept, a clause stemming actually from Roman canonical church law, however, seems without moral base in the ethical neutralized space of the market. Thus, the market seems to live off a moral consensus that it by itself cannot engender. The second paradox is the paradox of the liberal democratic state. On the one hand, this state grants the greatest possible private autonomy to the individual as is compatible with an equal degree of autonomy for all. With this liberal space, individuals can choose their own way of life, their religion, their ethics. The state has to be neutral with respect to these choices and questions of good life, but on the other hand, the same state, because it is democratic, is not sustainable if every individual retires into private life and pursues only their egoistic advantage. It depends on individuals embracing a common good orientation, a Republican ethos maybe one can call it. I'm using this for lack of a better word, where they set aside their selfish interests and collectively work for the common good. Its conception of justice has to be self-standing and based on an overlapping consensus achieved only through public reason, as conceptualized by Rawls. This paradox follows straight from the definition of law as a system of coercible norms. Since law only takes care of coercible behavior, it cannot demand or enforce moral attitudes. This moral attitude is necessary, however, for law to perform its integral function as an expression of democratic self-rule by a people. So Habermas tries to mend this problem by attributing a dual character to democratically engendered norms. They are legal norms to the extent that they are enforceable. They are attributed a moral character by Habermas to the extent that the process that engenders them requires the ethical commitment of the citizen to the common good and to the moral community of all citizens in the state. I'm quoting Habermas. Legal norms are at the same time, but in different respects, enforceable laws based on coercion and laws of freedom. While democratically legitimate law is not based on moral principles, it does depend on morally justified procedures guaranteeing a fair outcome. For, and again, I'm again quoting, without religious or metaphysical support, the coercive law tailored for the self-interested use of individual rights can preserve its socially integrating force only insofar as the addressees of legal norms may at the same time understand themselves taken as a whole as the rational authors in a common good conception of these norms. End of quote. These moral principles have to be anchored in a moral community of citizens. Thus, modern law lives, again, of a solidarity concentrated in the value orientations of citizens, which it cannot produce out of and by itself. This solidarity, this was the second paradox. This solidarity issues from a moral ethical life world that capitalism and the modern state constantly undermine through their emphasis on private autonomy. Unacknowledged by theories of rational choice, a sense of justice must be presupposed to have developed which carries the burden of stabilizing a society of egoists. It seems thus that the stabilization of a liberal democratic society is, and I'm again quoting Habermas, based not on the coercive force of law, but on the socializing force of a life under sufficiently just institutions. End of quote. Even the modern legal discourse, therefore, remains embedded in a larger ethical discourse from which it receives what it by itself cannot engender. Thus, the idea that modernity could do away with the ethical world of pre-modern times, where moral, metaphysical, and legal notions were amalgamated to the point of indistinguishability, turns out to be another self-mystification. In reality, modernity undoes one ethical world only to recreate another on a different plane. In this respect, modern positive law is not very different from the spiritual law of our stipulated ideal typical society, where the two paradoxes of capitalist society on the one hand and the one of the liberal democratic state do not arise in the first place. In much of the post-colonial world, self-governing communities still exist outside the purview of the state and the law. We should not make the mistake in believing that all these are only pre-modern village communities. In India, up to 70% of the urban populations live under illegal conditions. More than 70% of housing is constructed illegally. 70% of software use in India is illegal. Around 70% of the labor market is organized outside the law. So this is very much a modern phenomenon. Indian society doesn't seem to need the assistance of law and the state to organize itself. It seems that the greatest part of the Indian economy thrives outside the law and does not require the assistance of the modern state and positive law. Instead, it rests on the capacity of partners in interaction to secure informally but binding agreements based on communicative action alone. This clearly falsifies Habermas' thesis that modern economic society can only be integrated with the help of positive law, but it reinforces his emphasis on the life world as a guarantor of a moral background consensus, without which even the modern state and its law could not function. India's moral ethical life worlds, or spiritual life worlds, are self-governed, of course, in a way that cannot be called democratic in a modern sense. But as Habermas rightly emphasizes, every social interaction that comes about without the exercise of manifest violence can be understood as, at least as a possible solution to the problem of coordinating human action. The prima facie legitimacy of such interactions, provided they do not rest on manifest violence, oppressive violence, cannot therefore be dismissed out of hand. They are self-determining, at least in the sense that they have not been tampered with by an extraneous authoritarian power like the state. And where this power has to be dealt with, it is engaged with and renegotiated and rendered porous by what appears as illegality from a state-centric perspective. Porous legality, as Liang points out, are often the only modes through which the people can access and create avenues of participation in the new economy. And we will hear more about this in Kaveri's paper. They offer ways for people ordinarily left out of the imagination of modernity, technology, and global economy of inserting themselves into these networks. The state and its law is thereby re-liquefied, reabsorbed into the lava of the life world from which it once emerged to organizationally outflank, to use a word by Michael Mann, the individual people. So in conclusion, we have seen how a spirit-based legal system ideal typically works. We have ascertained that it can legitimately be called a legal system. We have compared it on the level of ideal types with a system of positive law, and we have found that it is relying on a moral background consensus like the positive legal system, the only difference being that the background consensus supporting the positive legal system is self-conflicting. The assumption of a shared moral, ethical, and spiritual background understanding poses no problem as long as life worlds continue to be enchanted and communicative action is not cut loose, as Habermas says, from the ties of sacred authorities and released from the bonds of archaic institutions. End of quote. However, as we have seen, Habermas would be mistaken in assuming that those life worlds are therefore not coeval, less modern, less internally differentiated or pluralized. Our ideal typical scenario does not overtax the integrating capacity of communicative action, even if we look at it as a modern economic society. In Habermas' view, only small and relatively undifferentiated groups are able to integrate by regulating behavior through strong archaic institutions. This clearly seems to be falsified by our scenario. It may rely on archaic institutions like spirits, but it is therefore not necessarily small and undifferentiated. And as we have seen, even a system based on positive law necessarily presupposes a shared moral background understanding as a precondition for its citizens to be able to engage in contracts. To eliminate this first paradox and to eliminate the second, to support the Republican ethos that is required for its democratic laws to be more than the expression of a modus vivendi, as Rawls would call it, between differently powerful private interests. How modern society is achieving this when it cannot rely on an overtaxed communicative action system is at least as mysterious as the judicial efficacy of spirits. Thus, we can reply to the objection that spirits do not exist by questioning the existence of the Republican ethos that is required for positive law to be legitimate and whether democratic positive law is suited to overcome the persistent legitimation crisis in late capitalism, as Habermas once called it. With the failure of democratic positive law to make up for the legitimation crisis of neoliberal democratic society in particular, we should consider dropping this paradigm altogether and instead take post-colonial legality with Upendra Bakshi, with its legal diversity and paradigms of porous law as developed by and people from the Alternative Law Forum, seriously. They offer avenues of participation not previously conceivable in Western contexts. And within the blinds of the modern episteme, they are completely rendered invisible. Even though legal diversity and porous legalities may be the paradigms followed in much of the post-colonial world, they may not be able to displace the normalized paradigm of Western legal regimes in practice. But as far as the philosophy of law is concerned, the stable location of positive law as part of modern political theory is becoming doubtful under the impact of really existing alternative legal modernities in most of the world. Thank you.